Good afternoon, and welcome to this panel discussion. Fighting Modern Monopolies, What's at Stake in Antitrust Enforcement. I'm Russ Feingold, the president of the American Constitution Society, the country's foremost progressive legal network with nearly 200 student and lawyer chapters across the nation. Through our diverse nationwide network of progressive lawyers and law students and judges and scholars and advocates and many others, ACS's mission is to support and advocate for laws and legal systems that redress the founding failures of our Constitution, strengthen our democratic legitimacy, uphold the rule of law, and realize the promise of equality for all. And since 2017, the State Attorneys General Project at ACS has worked to highlight the important work of state attorneys general by featuring them in events like this one. If you aren't already, I encourage you to become a member of ACS. Go to acslaw.org, where you can join and find more information about events like this one. And I also want to really encourage you to attend our first ever national convention outside of Washington, D.C., which will be held this year in Atlanta, Georgia, from June 6th through June 8th. Our national convention is a wonderful opportunity to network with other progressive lawyers and law students and to hear from leading voices in the progressive legal movement, including this year, a featured speech by Federal Trade Commission Chair Lina Khan. Now, turning to the topic of today's discussion, Americans have felt the effects of increased corporate consolidation as consumers, as workers, and as owners of small businesses. Consolidation and anti-competitive practices in all industries, from big tech and news media to airlines and healthcare institutions, lead to higher costs, reductions in services and wages, fewer choices, and lower quality goods and services. At their core, our antitrust laws seek to protect and maintain fair competition. And fair competition benefits all of us. It contributes to lower consumer prices, better quality goods and services, a wider variety of goods and services, innovation, and increased jobs and wages. In so many ways, antitrust enforcement affects our everyday lives. Both federal and state officials play pivotal roles in enforcing these important laws. Today, we are very thrilled to be joined by an exceptional set of antitrust enforcers who will be sharing their expertise and insights to help us understand the challenges that enforcers are facing and how we can secure the promises of our antitrust laws. So to get the conversation started, I will now turn it over to Elizabeth Odette, the Assistant Attorney General and Manager of the Antitrust Division in the Office of the Minnesota Attorney General. Elizabeth?
Thank you, Senator. Before we get to the substance of today's event, I'm going to introduce the panelists and do a few housekeeping matters. We have with us today Alvaro Bedoya, Commissioner of the U.S. Federal Trade Commission, a role he's been serving in since 2022. Prior to that, he directed the Center on Privacy and Technology at Georgetown Law, of which he was the founder. He has also served as Chief Counsel to the U.S. Senate Judiciary Subcommittee on Privacy, Technology, and the Law, and Chief Counsel for former Minnesota Senator Al Franken. We also have with us Gwendolyn Cooley, who is Assistant Attorney General for Antitrust in the Wisconsin Department of Justice and the chair of the Multi-State Antitrust Task Force of the National Association of Attorneys General, a role she's been serving in since 2021. In her role with the Wisconsin Attorney General, she has led multiple complex matters, including most recently leading 42 attorneys general in a lawsuit against Indivior, manufacturer of Suboxone, resulting in a $102.5 million settlement. She is also active in the American Bar Association antitrust section, and she is a leader and mentor throughout the antitrust bar. And we have with us Doha Mekki. She is Principal Deputy Assistant Attorney General for the Antitrust Division of the U.S. Department of Justice. Prior to serving that, she served as Special Counsel for Labor, and before that, Assistant Chief in the Defense, Industrials, and the Aerospace section of the Antitrust Division. She was also an associate in antitrust and financial services groups of an international law firm in New York. She is not only behind the scenes working hard on antitrust enforcement, she's often in public forums before Congress, giving speeches, appearing on news programs to raise awareness and make the work of the Antitrust Division more understandable and accessible. So to those few housekeeping matters we need to do before we get started. This afternoon's discussion is being recorded, and the recording will be available on ACS's website after the program concludes. For those interested in CLE credit, information is available in the chat and on the event webpage on ACS's website. You will need 2 code words to complete your record of attendance. We'll be providing those throughout today's discussion. There will be time today to have discussion for audience questions. To submit a question, please use the Q&A box at the bottom of the Zoom screen. Do not use the chat to ask your questions, as we will not be monitoring it and your questions will not be put in the queue. The CLE materials can be accessed via the links included in the event page. All right, now we can get started. So we're here to talk about antitrust, and antitrust is often a word that can make people's eyes glaze over for those who aren't practicing in it. So when we talk about antitrust and antitrust laws, what are we talking about? Gwendolyn, we'll start with you.
Well, I would say that in the olden days, when I first started practicing antitrust law 20 years ago, I could comfortably sit on a plane and tell people that I was an antitrust lawyer and have no discussion whatsoever with them afterwards. Nowadays, when you say you are an antitrust lawyer, as Senator Feingold alluded to, people have thoughts. And I think that increasingly people are aware, because of those big tech cases that we've brought, because of some big merger challenges that both the states and our federal counterparts have brought, people are more aware than ever. But I recognize not everyone is an antitrust practitioner. You're getting a CLE credit, so here I will make sure you get your money's worth. First up, the thing that we enforce, both we the states, including Elizabeth, and the US Department of Justice and the Federal Trade Commission, we all enforce the Sherman Act and the Clayton Act, and there are some others. So let's go into those a little bit deeper. On the federal side, US Department of Justice and the states enforce the Sherman Act. And that law bans both conspiracies between companies and bans monopolies from engaging in bad behaviors, what we helpfully call monopolistic practices. If you're really in the weeds, that's Section 1 for those conspiracies and Section 2 for those monopolistic practices. If I was helping you to cheat on your antitrust test, it's easy. It's Section 1 is 2 people, Section 2 is 1 person, right? Like that's my shorthand for you. I know that Principal Deputy AAG Mecki is going to talk to you a bit about the history of the Sherman Act and DOJ's really interesting role in enforcing that statute. But because I get to go first here, I get the privilege of noting that several state antitrust laws predate the Sherman Act, including state constitutions have antitrust provisions that long predate the Sherman Act. But the specific laws, and I know some of you who are listening will love this, those state antitrust laws include Iowa, Kansas, and others passed those laws before the Sherman Act. So we were here first, although we're still talking about the 1800s. So back to those federal laws that we all enforce, all 3 of us, US Department of Justice, the FTC, and the states, in a slightly different way, but we all enforce the Clayton Act. And that's a later statute, and by later I mean 1914. That's a later statute that Congress passed in order to ensure that its original idea of prohibition on anti-competitive mergers, to make sure that that was enforceable. So every time you're hearing in the news that big company A is merging with big company B, subject to antitrust review, that's what the people on this panel do, right? That's us. There's also the Robinson-Patman Act, which came later. Again, still, we're talking, Commissioner Bedoya is an expert on this, so I'm going to leave that one for him. But I think, what, 40s, 50s? And as well as the FTC Act, which was actually also, I think, in 1914. But again, we've got FTC here, so they can talk about that one. One final word on this. I know you all understand how federal agencies work, but you may not understand how attorneys general are folded into this. Like, for example, other than being good neighbors, why do I know what Elizabeth in Minnesota is doing? But, you know, so we enforce these antitrust laws together, and the state attorneys general work cooperatively through, appropriately, the National Association of Attorneys General And the AGs have a task force, the Antitrust Task Force, which is the thing that I lead. And that is the 270 attorneys around the country who do antitrust. And we work together in kind of what is essentially a nationwide law firm which is a surprising nationwide law firm because it includes the vast majority of the attorneys general. And we work together through that antitrust task force. That means, of course, that I get to bring cases both as the assistant AG for antitrust in Wisconsin, but I also then get to work with Elizabeth on cases. Oh, Elizabeth, we've got some cases together like Amazon. We sued with the Federal Trade Commission. We've had some others too. So we do get to work together with our colleagues across the country.
Thank you, Gwendolyn. So building off of that, Doha, can you give us a sense of, from your perspective at the DOJ, how and who enforces antitrust laws from the federal perspective?
For sure. First, thank you so much to the American Constitution Society for having me. It's really nice to be with all of you and also to chat among friends and colleagues in the enforcement community who I admire so much. And so let me try to frame my remarks around the special role of the Justice Department, but obviously acknowledging the really incredible impact that our colleagues down the street at the Federal Trade Commission have, and the many state attorneys general who not only have authority to enforce antitrust, but also consumer protection statutes that can really draw out a lot of the same themes and public goods that are really addressed also through antitrust. So the special role of the Justice Department is something that all of us in the Antitrust Division of the DOJ really internalize. Many people know that the role of the Attorney General is about as old as the United States itself, but the Justice Department, as we know it, was actually created in 1870 after the Civil War. And President Grant specifically created the department to ensure the rights, and specifically the 13th, 14th, and 15th Amendments that secured the liberty of formerly enslaved Black Americans who were newly citizens. And specifically, the role was to subdue groups in the South that really sought to infringe upon those liberties. And so it's about 20 years later that we get our first antitrust law, which is the Sherman Act. It's passed in 1890. It's a really special law because it borrows from, English common law. It's intended to deal with trust, the sugar trust, the whiskey trust, Standard Oil, which is really the first time that the Justice Department steps in and files a lawsuit, an antitrust lawsuit that breaks up a company. And the antitrust laws are special, our enforcement is special, because there are these democratic ideals that are promoted through the competition values that are enshrined in the law. And so at the Justice Department, we're constantly thinking about the private coercive power of certain corporations that can really affect every aspect of American life. And so sometimes that looks like the tech monopolies that have outsized control over the very information that we take in and can access to make decisions about our lives. It's about healthcare that can really determine not only whether you live or die, but the quality of your life. It's about food and agriculture, which we'll have some occasion to talk about later today. And so it really goes to every aspect of American life. And, one statute that or one type of antitrust enforcement that we do exclusively is criminal antitrust enforcement. Many people, who aren't practicing lawyers may not know that there are antitrust crimes. Price fixing, bid rigging, market allocation, wage fixing, no poach agreements. Those are all criminal violations of the Sherman Act. And so we have a thriving criminal program and 5 offices across the country that really do heroic work to vindicate the principles of competition across the entire US economy.
Excellent. Now moving to you, Alvaro, could you tell us what makes the FTC different than the DOJ in its enforcement of antitrust laws?
Thanks. Happy to do that. Let me also start by echoing Doha. It's a pleasure to be here with the three of you, and I'm grateful to be here with you, but also to be here under the auspices of ACS and follow Senator Feingold. I was just saying was who I sat behind for a little bit when I was on Senate Judiciary as a staffer. So how is FTC different? And look, all of this is against the backdrop of us working arm in arm with our colleagues up the street at the Department of Justice and at the State Attorney General's offices. But how are we a little different? We're founded in 1914 with the Federal Trade Commission Act. We are led by a chair and 4 commissioners. So leadership is a little different at the Federal Trade Commission. And one way in terms of how we do things that is structurally interesting to me is that we have these dedicated shops that bring certain kinds of actions on the antitrust side. So we've got conduct shops that investigate and prosecute anti-competitive conduct, and we've got merger shops that each specialize in their own, in a specific set of areas. So you have a shop that specializes in healthcare mergers. You've got a shop that specializes in energy, et cetera. And that a lot of our folks like that because it lets them build a lot of expertise over a long time in a particular area. Perhaps the most relevant way we're slightly different is in the authorities that we enforce. And so we also enforce Sherman, we also enforce Clayton, we also enforce Robinson-Patman alongside DOJ. The one authority that I think is really special is the Federal Trade Commission Act. And a little later on, I'll dive into this more, but this was a law that Congress passed initially to target a very specific list literally of conduct, and then backed away from that and said, actually, we want to leave this broad and we want to give the Federal Trade Commission discretion to adapt to changing economic circumstances, adapt to innovations in anti-competitive conduct, like literally innovations in law breaking. And so this was a special authority that we have that under Chair Khan, we are doing everything possible to reinvigorate. And so that in a nutshell is probably how we're on the surface level different from some of our colleagues.
Excellent, thanks. This creates a really great base for us to get going into the substantive discussion of antitrust enforcement. I'm going to pause here for another brief housekeeping matter, which is to give you all the first CLE code word, which is boardwalk. So that code word is boardwalk, and it will also be put in the chat. Okay, so now I'd like us to use the American food supply chain, an area we're all familiar with because we all need to eat. We all need to go somewhere to get what we eat, to explain how these antitrust laws work and talk about groceries we need to buy. We need to start with the farms where our food is grown or raised. And so, Doha, can you tell us about how antitrust enforcement looks at that level?
Yeah, so food and agriculture is one of my favorite topics to talk about in antitrust, particularly with audiences that may not know a lot about antitrust or fully appreciate the power of the antitrust laws. And so I think in thinking about what we were all going to talk about with this wonderful audience, it occurred to us that we're arranged, our agencies that is, are arranged kind of farm to table. And so I'm going to take the farm part of the food and agriculture system. But before I do that, I should have said earlier that one thing that makes the Justice Department special is that we are the law firm for the entire United States. We are the law firm for sister executive branch agencies. But one thing that I've learned in my work here is that there are actually myriad competition statutes that are sort of delegated to other agencies. And one great example of that, and a topically focused one, is the Packers and Stockyards Act. And so I'm really proud that on our watch here, we enforced the first known use of the Packers and Stockyards Act by the Antitrust Division to address a really nasty information sharing scheme involving very vulnerable slaughterhouse workers and chicken processors that were employing them and exchanging wage and benefit information and artificially suppressing their wages. And so we were really proud to use not only our Sherman Act authority, but the Packers and Stockyards Act to win back over $85 million for those workers, but also to start to restructure something called the tournament system, which is a system that keeps chicken growers, right, the farmers who raise chicks and then give them to chicken processors to be slaughtered for meat and such. It's a system that really outsourced financial risk to those growers and really kept them at the mercy to make like a livelihood, to pay back expensive loans, to help build chicken coops and such. And that was just a fundamentally unfair system. And so we used the deception prong of the Packers and Stockyards Act to start to reform some of those practices. More recently, a federal judge in Illinois approved a consent decree involving Cook Foods, which is one of the largest poultry processors in the United States. And the Antitrust Division alleged that they had violated the Packers and Stockyards Act and the Sherman Act by requiring independent chicken farmers to pay a termination penalty if they wanted to switch from working with Cook Foods to one of its rivals. And again, the antitrust laws are about promoting economic liberty. The ability to switch to get a better deal if you're not happy with an employer or a trading partner of some kind really goes to the core of economic liberty. And so this is something we're really excited about. The consent decree there required Cook to refrain from enforcing the penalty and also will require them to pay back termination payments that they've already collected. We also have a big amicus effort. Last year, we filed a brief in a private lawsuit against the John Deere company, where we argued that John Deere couldn't deny farmers access to the tools they need to repair Deere tractors. This is a huge issue for farmers all over the country. It is incredibly expensive to repair tractors and other farming equipment, but just the delay, right? Just the delay in repairing that equipment can not only cause time delays, but also cost these hardworking farmers a lot of money. And so, I'll wrap by saying we spend a lot of time thinking about agriculture at the Antitrust Division. And one of the most memorable parts of my time in this job was meeting with the National Farmers Union, I think in 2022, and just hearing about their experiences, right? Ranchers, cattlemen, chicken growers and others. And I know that the work that we do really matters because a cattle rancher from South Dakota, I'll never forget this, came up to us, the Assistant Attorney General, Jonathan Cantor, and I, and said, my grandparents fought these fights. And if they knew that the Justice Department cared, they would be so honored. And he was a little tearful and choked up. And that just meant everything to me and gave me a sense that we're doing the right thing.
Excellent. And thanks for the farm aspect of it. Moving from farm, there's a middle step before ultimately food is available to consumers in the grocery store. Alvaro, I'm going to turn to you about where potential antitrust issues are popping up in that middle step.
Sure, at the retail level. So as Gwendolyn suggested, we enforce the Robinson-Patman Act, and this is a law passed in 1936. And to understand what this law is and what it does for creating a level playing field in retail, I think it's really important to go back and understand why we have it. And we have it because of a series of things done by the A&P back in the 1930s. The A&P was a massive grocery chain, and it was going into small towns. And I think it's really important that people understand that the A&P just wasn't better at what everyone else did. Actually, it just offered a different kind of service. So instead of having lots of staff that could assist customers, there was a lot less staff. Instead of offering them delivery, they said, you have to come here, you have to get it here. Instead of offering credit to needy shoppers, they said, no, absolutely no credit will be given out here. And another strategy they used was in secret discounts and through kickbacks. One thing the A&P would do is they'd say, hey, we have all this power, we have all this market share. They would go to suppliers and say, you got to give us some secret deals. You have to give us secret discounts. And they critically, these discounts were not offered to the independents and the smaller retailers. And critically, they also didn't have anything to do with efficiency. It was as if the A&P said, well, because we're buying at scale, as a result, you can produce this at a cheaper cost, therefore, we'll buy it at that cheaper cost. This was just a pure exercise of market power. And so Congress stepped in 1936 and prohibited that. The other thing Congress did was get at kickbacks. Another kind of sneaky strategy that the A&P used was in what was called at the time dummy brokerage. Sometimes it's called commercial bribery, the much simpler term of kickbacks. But the A&P knew that price discrimination, those secret discounts that I was just describing, they knew those were illegal. And they were actually illegal since the days of the Clayton Act in 1914. And so one way the A&P got around this was by designating a broker and saying to the supplier, hey, we'll pay the same price as everyone else. But if you want to sell to us, you have to use this broker. And actually, it's not our broker, it's your broker. So you better pay your broker. And so this broker, which was owned by the A&P, was getting kickbacks in the form of brokerage fees from suppliers. And this was one way the A&P was, again, extracting secret discounts and whatnot from these suppliers. So, fast forward to the modern day, for the last, 20, 30, 40 years, even though this law used to be a mainstay of antitrust enforcement, it has largely fallen into disuse. And there really hasn't been a case under Robinson-Patman from the federal government in about 20 years. There's been an active plaintiff's bar that's doing terrific work. But looking at 2024, why does this stuff matter? And I really appreciate, Doha, how you brought it home to the experiences and that you heard meeting with the National Farmers Union. I had a very similar set of experiences over the last year or two meeting with independent grocers. And what you see when you meet with independent grocers is that, again, they provide a service that's different from the big boxes. So, over time, my team and I have met with the grocer serving Pine Ridge, South Dakota, and the Ogallala Lakota community, to the grocer serving Black Wall Street in Oklahoma, in Tulsa, and I have my own experience in Louisiana and in visiting, Latino and Hispanic groceries, that these are folks providing products that are often tailored to their communities in the way that big boxes aren't. If you visit the store in Pine Ridge, South Dakota, and in Black Wall Street, they're going to be different in certain ways. But one thing you see across both of them is that they are so grounded in their community. They've got T-shirts from the schools, all around. They've got art from students. They've got community organizations that are in their stores. I think this is a really important service they provide the public to the communities they serve. And Robinson-Patman, I think, and I think Chair Khan thinks this as well, she started this whole effort to revitalize the law, is that it's important that we have those competitors on the playing field. So that's something I'm really excited about in terms of our work on retail grocery.
Excellent, thank you. And at this point, we're going to make a slight change where Commissioner Bedoya and his FTC colleague are going to leave the room briefly while we talk about the next subject, and then he'll come back when we're done speaking about that subject. So Gwendolyn, we've moved to that past the middle person now, between the farm and the retail, and moving to the grocery store level, us, the consumer that walks in the store and looking for things, the people maybe who work at the store. Can you talk to us about particularly high-profile grocery merger that is the topic of much discussion, and maybe something that someone on an airplane might want to ask you about if they know that you work in antitrust?
This is almost certainly something that if you're sitting on an airplane, people will want to talk about. So first, and the reason why I don't have to turn off my camera, I am not prosecuting this case. That said, as chair of the task force, I can talk about the Albertson-Kroger grocery store merger generally. So there's a number of states that are challenging this merger. Both Colorado and Washington state have state law cases in their state courts under their state antitrust laws. And there are a group of states that are working with the Federal Trade Commission to challenge that merger in federal court in Portland, Oregon. We didn't discuss this, but I'm going to just note for the record, because Commissioner Bedoya would ultimately vote on that kind of thing, that is why he is not listening to this part of the call. So just to explain that to you guys a little bit better. So there's that case that's in federal court in Portland, Oregon, FTC, and a bunch of states. What I can share from public sources about this is that we see that whole chain of concerns with this merger. We see upstream, and these are all allegations, obviously. We see these upstream concerns with the producers, in other words, the farmers, the suppliers. We see concerns about the ability to leverage in those markets. There are labor concerns at the actual grocery stores, right? There will be reduced opportunities for employment, particularly when you have two grocery stores and you merge to one, you're only going to keep the one open. Then there's fewer opportunities to have at all levels, right? Grocery stores employ a lot of people, including my own father. And also there's the downstream concerns about the potential for price increases for consumers due to the fact that when these two, when grocery stores like this compete head to head, they're really monitoring each other's prices very closely. So even a big box, it's going to be tailoring its prices to the nearest competitor. Often in merger cases, parties will propose what's called a divestiture, which is where they sell off an asset ostensibly to help alleviate competition concerns. More often, to speak plainly, it is to make us go away. And by us, I mean the antitrust enforcement agencies. In Albertson Kroger, the parties have proposed divesting 413 grocery stores nationwide to C&S Wholesale Grocer. It's important, just for a second. As the Washington AG's complaint notes, there are many locations where the merged entity would have a monopoly, even with the proposed divestiture, and that C&S is a wholesaler, right? We just talked about that. Being a wholesaler, rather than a retail grocer, may not have the expertise to make that work, may not be able to tailor that grocery store to the needs of the community, right? You know that the FTC is both not on this call and can't comment on this, but when I look at their complaint and I look at the state's complaint, I can see how important it is, and this is something we all know, that the prices of groceries have risen by 25% in the last years. This is not the merger of two cassette tape manufacturers who are doomed to go out of business whether they merge or not. This is a dynamic and growing industry, and it is competition that keeps prices low. Now, one other thing to add about divestitures from personal experience, and if we zoom back up the chain into that processor step, as you probably know, Wisconsin is all about cheese and dairy. We love it. I personally love it. In 2020, on a different merger, I sued to block the sell-off of Dean Foods assets to DFA, as we were concerned it would create a monopoly in the dairy processing market in Wisconsin. I successfully got Dean Foods to divest both dairy processing plants that I wanted, one just outside of Wisconsin and one in De Pere. About 2 years later, we received notice that both of those plants that we had ordered divested were closing, which meant that farmers had nowhere to sell their milk. It meant that schools, particularly schools in the Chicago area, had nowhere to buy milk for their students, and that all those dairy workers were out of a job. This is not uncommon to have this happen. One recent study noted that in pharmaceutical mergers, another important product for all of us, 25% of pharmaceutical merger divestitures failed. So you've got multiple failed divestitures, and those failures mean something to people. So we take this very seriously, and I would expect that my colleagues across the country who are prosecuting this case are also thinking about the potential for failed divestitures in this situation when they think about the proposed remedy. So I think those are the kinds of things that we're thinking that my colleagues across the country, again, not me, my colleagues across the country are thinking about in the Kroger-Albertson case. Now, as much as I love talking, I would be remiss if I did not note that our lovely moderator, Elizabeth, is a star in the antitrust AAG community and does a ton of the agriculture stuff for the states. So, Elizabeth, do you have anything you want to add to that?
I do. And as you were talking, it made me think of how the merger that you talked about, and we can invite Commissioner Bedoya and his colleague back while I'm talking about this, because I will step away from that particular merger. But it is an example of how the FTC is looking at things on a very national scale, but sometimes needs to get hyper local, as you mentioned, where there's overlap. And so state collaboration with that is hugely valuable, because states AGs know their people. They're hearing from constituents on a daily basis about a variety of issues. And so it's helpful to have that collaboration on large national things where there are local issues. I would also mention that the USDA, which also enforces the Packers and Stockyards Act that Doha mentioned, we've worked together now to create over 30 plus state AGs and the USDA in a partnership. And so we're moving forward with that. And it's great because there's money set aside, not only for grants to support enforcement and academic studies, but also for the USDA and the state AGs to get together on specific issues to learn from each other. What the USDA is collecting in data, I think it just goes to show kind of how we're able to work. Again, this is another thing where USDA has all this data we may not know. We're sitting here with potentially without economists of our own, and they have economists that can tell us, well, by the way, in this particular industry, we can tell you this is where the data is and this is the analysis that we've done. So that partnership continues and we're very excited about it. Okay, so we've kind of worked our way through in an example of the food system. And now we're going to kind of talk about some developments in policy and otherwise that have happened over very recently, to be honest. Some significant documents in the last couple of years, including the merger guidelines, a policy statement regarding the scope of unfair methods of competition under Section 5, to name a few. And so we're going to work through some of those. So we'll start, Doha, with you to talk about the merger guidelines.
Sure. So one of the things that we do at the Antitrust Division, and this is true of our sister agency, the FTC, and other competition enforcers, is have a robust policy portfolio. And one of the things we do in that policy portfolio is to issue guidance documents to help the public better understand how we exercise our analytical skill set to enforce the statutes that Congress tells us to enforce. And the merger guidelines are interesting because they seek to provide clarity about how the agencies will review mergers. And the very first merger guidelines came to be in 1968. And every single administration since 1968 has revised those guidelines in one form or another. And so we, the DOJ and FTC, I should say, it's a joint document, and we set out to be as thoughtful as we possibly could. It is very important not only to the Assistant Attorney General, Jonathan Cantor and myself, but also Chair Lena Khan and the rest of the commission to make sure that our enforcement is participatory, because the way that antitrust accrues to our democratic values and ideals is incredibly important and really can't be understated. And so we launched a process to hear from the public about whether and to what extent the merger guidelines should be updated. And that was an incredible process. We had listening sessions. We got 5,000 comments from the public. And after we got that feedback, we set out to write guidelines that actually speak to how the agencies undertake merger review. And I'd be remiss if I didn't acknowledge the incredible work and intellect and time and dedication of agency staff, particularly Dave Lawrence and Susan Athey at the Justice Department, who poured all of themselves into drafting that document over many months. And so there are a few things that are different about this set of guidelines. The first is that it's the first set of merger guidelines that actually cites to binding precedent. You might be surprised, right? If you're a different kind of lawyer on this call, it might shock you to know that prior iterations of the guidelines really did not cite any case law. But we have a very steadfast belief that our job is not to fill the antitrust laws with our own notions of what's economically best, right? Congress actually wrote a law, and it is our job, particularly those of us in the executive branch, to faithfully execute that law. In fact, it is our constitutional obligation, right, to take care that the laws be faithfully executed. And so we sought to write guidelines that cite the statutory language, but also the laws that's been interpreted by the Supreme Court and the courts of appeals. Another thing that the guidelines do is to really ground our analysis of the facts into market realities. One thing that's really changed, or one of many things that's changed since the last iteration of the guidelines in 2010, is the way commerce is transacted is very different. The way we think about the valuation of companies is very different, right? It's not revenue, it might be stock price, for example. And that influences how we think about mergers, the way they transact business, the fact that many businesses, right, like there's no such thing as big tech, all industry is tech. There are platform markets, there are serial acquisitions, they're just sort of new business practices or newer business practices that really weren't accounted for explicitly in the prior iteration of the guidelines. And so this set of guidelines squarely addresses those types of concerns. We released a draft in July of 2023, and we received tens of thousands of comments. We're really happy that the vast majority of them were supportive. That was about 50% of them. About a quarter of them were largely supportive and gave us constructive feedback. And I'm really proud that we were responsive to that feedback. We improved the guidelines based on what we heard from practitioners, from economists, from policymakers, and from regular people who live under the market conditions that our enforcement choices beget. And even the folks who really did not like our efforts to, write a set of merger guidelines that was appropriately reflective of the stringent merger review process that we undertake at the agencies, even that was very helpful because, again, it helped us clarify language. It helped us understand where our intentions were not really understood by the public. And so we're grateful for that feedback too. And so we finalized the merger guidelines in December 2023. They are operational, and we have not yet had an opportunity to get a decision applying those merger guidelines, but we are hopeful that by being faithful to the law, being faithful to the statutes as written by Congress, that they will be tractable and they will be faithful to the law that we're tasked with enforcing.
Excellent, thank you. So now moving to the Section 5 policy statement that I mentioned. Alvaro, can you tell us what it is and what it's all about?
Sure. And I realize it may sound strange to folks coming in from out of antitrust to say this is a really exciting document that was just issued about something called Section 5, but it really is. And let me explain a little bit why. As I mentioned earlier, we were created in 1914, and when Congress created us, it was in the wake of some court rulings that had taken this law where Congress was really infuriated at the state of trusts in this country and what they were doing to regular people, to the economy, to small businesses. And they passed a strong law, and courts undercut it by interpreting it narrowly. And so Congress passed the Clayton Act, and alongside Clayton created the FTC and charged us with stopping unfair methods of competition. And what's really important to know about this law is that unlike most other laws, if you look at Sherman, if you look at Clayton, if you look at Robinson, Patman, they prohibit specific things. Now, there's broad language that can be adapted to lots of different situations. But with the unfair methods law and that mandate, Congress started out that way. It actually created a list of unfair methods of competition, voted that bill out of a committee. I think it was in the House. And then Louis Brandeis, along with others, I think it was George Rubley, persuaded upon President Wilson and persuaded Congress to change gears and to instead enact a broad law that was supposed to adapt to changing circumstances. Now, if you read the debates on the floor of Congress, they give two very clear reasons why. The first was Congress recognized that it wasn't ideal to wait until harm was done to competition before moving to stop it. Congress wanted to stop antitrust violations in their incipiency. I think one of the words was used was in the embryo or embryonic stage. So they wanted to fix things before they got completely broken. And the second thing is that they realized that there were a whole series of things being done in the economy, anti-competitive practices that violated really the spirit of the antitrust laws, but didn't check every single technical box that would be required under Section 1 or Section 2 of the Sherman Act, or the Clayton laws that were being developed and passed alongside the FTC Act. And so for those reasons, they created a really broad law that, again, Congress wanted to meet the new innovations in anti-competitive practices. So why is this policy statement really exciting? Well, it's exciting because initially, this authority, which is called the standalone, Section 5 authority or standalone unfair methods authority, was used quite a lot by the Federal Trade Commission. And when courts of appeal and the Supreme Court considered actions that we brought under this authority, look, sometimes they struck us down, sometimes they upheld us, but every time they reaffirmed that the nature of this law was one that was supposed to be adapting to current circumstances, was supposed to arrest anti-competitive practices in their incipiency, and that was supposed to get at violations of the spirit of the antitrust laws that may not check every single box. So Supreme Court decided different ways, but they affirmed this is a broad, evolving standard. Unfortunately, over the last couple decades, the views of this law shifted. And as a result, there was the prior policy statement interpreting it really cabined it to the authorities in Clayton and Sherman and named a few other things that may be covered, like invitations to collude, but pretty much tightly constrained this authority to the other laws. And I remember when my colleague, Max Miller, I have two great attorney advisors, Max Miller and Catherine Sanchez, he explained that really on the face of it doesn't make sense. Why would you pass a law whose sole purpose is to enforce other laws? That makes no sense. And so with this Section 5 policy statement, under Chair Khan's leadership, Commissioner Slaughter and I felt strongly, together with her, that we needed to return to the original purpose of Section 5. And what we did is, and what our staff did, is survey all of those Supreme Court precedents to tease out what is an unfair method of competition. And we said, first of all, it needs to be an unfair method. It needs to be a method of competition, right? It can't just be a condition of the marketplace. Number one. Number two, there's two indicia that we look for. One is conduct that is coercive, exploitative, restrictive, exclusionary. And second, we're looking for conduct that changes competitive conditions. So perhaps it keeps someone off the playing field, right? It keeps them from competing, not on the merits, but just by removing them from a particular market. And we've already used this authority I believe we used it in some terrific cases, settlements to stop non-compete clauses that were being used by glass manufacturers, by security guards. And this is one of the most exciting areas that we're working on right now, how to apply this authority, this reinvigorated authority, to new conditions in the market.
Excellent, thank you. I'm going to pause for that last administrative matter here. We have the second CLE code word. It's chance. So the last second CLE code word is chance, and we'll have that in the chat as well. Okay. Gwendolyn, before I let you respond and answer to how states fit into those two things that we talked about, I'm going to hit one of the questions that we got in the Q&A, because it kind of, I think, ties in with how states perhaps fit with these various things going on at the federal level. You know, state AGs are a political elected position. Many or most have a political affiliation associated with it. That means that there may be some differences of opinion about a variety of subjects. The question in the chat was kind of how or if this has been affecting the ability to enforce antitrust.
I would say that there is a surprising amount of overlap in the viewpoints on antitrust. Just to take one example, in the Google search case, which is currently pending, so I'm just going to talk about logistics. The state of Wisconsin, Michigan, California, right? We're currently blue states at the AG level. We joined AG Paxton in Texas and a host of other Republican states, and the US Department of Justice, which was then the Trump administration, obviously now the Biden administration. And we were all together on the same complaint. The rest of the AGs were all together in what was the Colorado and Nebraska complaint, which a blue state and a red state. So even in cases where we didn't have the same exact complaint, there was still overlap between which kinds of states were on which things, right? Can you think of states that are more different than California and Texas? So we definitely see a lot of working together because these issues matter to Americans for real, right? Certainly agriculture, we already talked about, right? Does it really matter what your party is if you're concerned about grocery stores? Not really. Antitrust is one of those places where we are still working well together. I'm not going to say that there's no conflicts. Obviously, we were talking about the merger guidelines just now. The states are very engaged on the merger guidelines. We issued, overall, during the course of the process, we issued 6 sets of comments totaling over 250 pages. God bless you at the FTC and the US Department of Justice for reading all of those. We really, really appreciate it. Most of those comments fell in that bucket that we heard about being supportive, right? About 25 states ultimately saying in various iterations, appreciating the new direction. And there are certainly AGs who would have even gone further and created more structural presumptions. For you non-antitrust lawyers, that means presuming at the outset things, for example, like that big merging parties merging at all are problematic, presumptively. But we also had a dissenting state that disliked the direction of the merger guidelines and in particular raised questions about labor markets and whether it was appropriate to even consider upstream markets and merger analysis, which I think is going to anticipate your next question a little bit.
So yes, we're moving into one last segment, if we can squeeze it in with the last 6 minutes that we have. In the last few years, we've seen a renewed focus on the role of antitrust enforcement in protecting labor markets. Although you mentioned settlements involving non-competes, Doha, I'm going to want to give you a chance to talk about what the DOJ has been doing on the labor front.
Sure. Are you coming to me, or would you like the commissioner?
Why don't we go to you, and
Okay.
we'll come back to him if necessary.
Okay, awesome. So labor is near and dear to our hearts. It's part of the fabric of our work at the Antitrust Division. I have had the privilege of doing a lot of different roles at the Justice Department, but one of my favorite was being counsel to the current Assistant Attorney General's predecessor, a guy named Macon Delrahim, who gave me a lot of room to try to build out a vision of labor competition, policy, and enforcement at the Justice Department. And way back in 2019, I testified before Congress that the Antitrust Division was committed to thinking about labor market effects of mergers, that we would continue to enforce after a very long gap information sharing schemes that hurt workers, and that we would file where warranted indictments around wage fixing and no poaching arrangements. And I'm really proud to say that we have done all of those things under our watch. One that we are most proud of, especially proud of, is a merger involving Penguin Random House and Simon & Schuster. Again, for the uninitiated, most of the time when we go to court to challenge a merger, we're typically talking about a product or a service that maybe both companies make that might be affected by the merger, but not so with Penguin Random House, Simon & Schuster. This merger theory was that if we allowed those two companies to combine, that the result would be a reduction in competition for author advances, and that authors, which are a type of worker, would be worse off if they were able to combine. And we were very proud that we were successful at trial, and the merger was stopped and subsequently at the end. But I'm proud of the way we put on that case. At trial, our first witness was actually Stephen King. And he talked about how his life was made better by the ability to, get advances that really funded this work. If you stop and think about it, it takes a very long time to write books. People need to be able to eat. They need to be able to pay mortgages and rent while they do that work. And this is an important part of our culture, our national mythology, right? The stories that we tell about ourselves are very, very important, and it is critical that we preserve the free and open and vibrant marketplace to tell those kinds of stories. We heard from literary agents who testified that they try to bring out the voices of women and people of color and others for whom their stories may not ever get told without competition for these advances. And so labor is very, very important. And I won't ask you, Gwendolyn, which state AG was concerned about labor market effects, but I will point out that the Supreme Court decided in 1926 that labor markets were within the heartland of Sherman Act enforcement. And so this is law that's been on the books for almost a century. And it's really critical that we treat labor market effects as just as consequential as product market effects, because at the end of the day, people are the objects of the law solicitude, right? Like people don't exist to serve markets, right? Markets serve people. And so labor market enforcement is very important.
So because we have 2 minutes left, Alvaro and Gwendolyn, in order to answer kind of the labor piece of it, I also just want to ask kind of, this fits in with, there has been public criticism that antitrust enforcers are doing something novel and seeking to expand their authority. In some instances, this relates to the labor enforcement that Doha mentioned. In kind of the concluding remarks you have, can you kind of talk about, how, from a federal level or from a state level, kind of how that's been absorbed?
Commissioner first, obviously.
Thank you. I'll be brief. First, let me stress that the work that Principal Deputy Attorney General, Assistant General Mecki is describing is truly monumental. Having a successful merger challenge on labor grounds is a historical achievement, and everyone should recognize that. When folks say we're doing something novel, 9 times out of 10, or maybe 8 times out of 10, let me say, the clear answer is we're actually returning to what Congress envisioned in creating the authorities that we enforce and the agencies which we help lead. I described the Section 5 policy statement. Let's talk about labor. You read what John Sherman said in the floor of the Senate in 1890. He said that one of the key indictment against trusts is they command the price of labor without fear of strikes. If you read the text of the Norris LaGuardia Act in 1932, Congress made a policy statement that it should be the focus of agencies like ours to ensure that the individual unorganized worker gets a fair shot when negotiating with employers, specifically through collective bargaining. And so I think that across the U.S. Department of Justice, across speaking for the Federal Trade Commission, as a commissioner for myself, I think that what we are really doing is returning to the original intent of these laws as the folks who gave us those laws and gave us our agencies intended them.
The only thing I would add is I think that I think it was just today, the US Supreme Court denied cert in the Desland case, which is a no poach case in Illinois. States have been long concerned about no poach. No poach is agreeing with a rival not to poach your employees, right? Like that seems to be squarely within the Sherman Act. And the Supreme Court denying cert makes me think that that's actually the right answer. So I think the states are super interested in this and have been very high profile on this. Washington State had sued something like 185 chain franchises for these no poach agreements. So we're continuing to work on that. We have a labor committee that's working on these issues. We're working cooperatively with our federal counterparts on this. So labor is something that the states are tremendously interested in.
Excellent. Doha, do you have anything to add before we wrap up?
No, if I could just offer just 20 seconds of a wrap up comment. Look, we're really lucky, all of us on this call, to do what we do. We're enjoying a bipartisan moment of interest, time in the sun for antitrust, and I think it's really important. So for the law students that are watching, antitrust is a really great public service. It goes to every aspect of American life. If you care deeply and passionately about the American people, as all of us do, you should think about a career in antitrust, because you can really make a difference for real people. And I think there are wonderful folks, including in my department, who prosecute hate crimes, who vindicate civil rights, people who vindicate political rights, right? Protect the franchise, voting rights and such. But remember that economic liberty is a really important third plank of a whole citizenship, and antitrust is an important part of that effort. So it is a wonderful, wonderful profession that all of us have. And I think I speak on behalf of everyone that we all invite you to join us at the state and federal level.
Could not have summed it up better myself. So thank you for doing that, Doha. We thank everyone for joining us today. Thank you, panelists. It was wonderful to get this group together to talk. I wish we'd had more time, but thank you all for participating. And like Doha said, look for more opportunities if you found the discussion of antitrust interesting to you. Thank you.